On January 14th, the Supreme Court issued its first opinion of 2021 with the Chicago versus Fulton case. This case was argued in October of 2020, but the opinion was just released. Here is the opinion as follows. Supreme Court of the United States, Syllabus, City of Chicago, Illinois versus Fulton et al. Certiorari to the United States Court of Appeals for the Seventh Circuit. Number 19357. Argued October 13, 2020, decided January 14, 2021. The filing of a petition under the Bankruptcy Code automatically creates an estate that, with some exceptions, comprises all legal or equitable interests of the debtor in property as of the commencement of the case, 11 U.S.C. 541A. Section 541 is intended to include within the estate any property made available by other provisions of the Bankruptcy Code. Section 542 is one such provision, as it provides that an entity in possession of property of the bankruptcy estate shall deliver to the trustee and account for that property. The filing of a petition also automatically operates as a stay applicable to all entities of efforts to collect prepetition debts outside the bankruptcy forum, 362A, including any act to obtain possession of property of the estate or of property from the estate or to exercise control over property of the estate, 362A3. Here, each respondent filed a bankruptcy petition and requested that the City of Chicago return his or her vehicle, which had been impounded for failure to pay fines for motor vehicle infractions. In each case, the city's refusal was held by a bankruptcy court to violate the automatic stay. The Seventh Circuit affirmed, concluding that by retaining possession of the vehicles, the city had acted to exercise control over respondents' property in violation of 362A3. Held. The mere retention of estate property after the filing of a bankruptcy petition does not violate 362A3 of the Bankruptcy Code. Under that provision, the filing of a bankruptcy petition operates as a stay of any act to exercise control over the property of the estate. Taken together, the most natural reading of these terms is that 362A3 prohibits affirmative acts that would disturb the status quo of estate property as of the time when the bankruptcy petition was filed. Respondents' alternative reading would create at least two serious problems. First, reading 362A3 to cover mere retention of property would render 542's central command that an entity in possession of certain estate property shall deliver to the trustee such property largely superfluous, even though 542 appears to be the provision governing the turnover of estate property. Second, respondents' reading would render the commands of 362A3 and 542 contradictory. Section 542 carves out exceptions to the turnover command. Under respondents' reading, an entity would be required to turn over property under 362A3, even if that property were exempt from turnover under 542. The history of the Bankruptcy Code confirms the better reading. The code originally included both 362A3 and 542A, but the former provision lacked the phrase "or to exercise control over property of the estate." When that phrase was later added by amendment, Congress made no mention of transforming 362A3 into an affirmative turnover obligation. It is unlikely that Congress would have made such an important change simply by adding the phrase "exercise control" rather than by adding a cross-reference to 542A or some other indication that it was so transforming 362A3. 926 F3D 916, vacated and remanded. Justice Alito delivered the opinion of the court, in which all other members joined, except Justice Barrett, who took no part in the consideration or decision of the case. Justice Sotomayor filed a concurring opinion. If you would like to read Justice Alito's or Justice Sotomayor's opinions, they are in the description below.